arbitration panel will be moderated by Rachel Osibo, partner Osibogo and Partners. Rachel, please can you join us? We will have 3 arbitrators, with the lead arbitrator being Mr. Chikwendo Madumere, partner Madumere and Madumere. Please join us, sir. We have Mrs. Yejide Oshunkeye, who is the secretary of CIArb Nigeria branch, joining us as arbitrator. Then we have Mrs. Rose Nwosu, managing counsel, Rose O. Ojako Wosu and Co. We have the claimant counsel, Jokpa Otake, who's an associate of Babalaki and Co. He'll be joined by Kinyovo Dafe Akwedeye, I'm sorry. Osasiwa Edowande, counsel at Chronicles Advisory. Respondents will be played by Latif Yusuf, founding partner, lawyer and partners, and he'll be joined by Kinyovo Dafe Akwedeye of Compos Mentis Chambers. Parties are Mrs. Oluwakemi Eweje, representing the Chinese company. She's a partner in Patrelli Partners, and Efosa Ewere, who represented the Nigerian company.
Could I have the parties stay in front, please?
So I'll hand over to Rachel.
Thank you, Deborah. Good afternoon, ladies and gentlemen. Today's mock arbitration seeks to address 2 issues: the case of the emergency arbitrator and the pathological arbitration agreement. Now, the new Arbitration and Conciliation Act, which has not been passed yet, but which we are hoping will be passed soon, seeks to bring arbitration law in Nigeria to be at par with other arbitration seats. The essence of that is to make Nigeria an attractive destination for arbitration. One of the issues that has been provided for is the ability of partners to be able to request an emergency arbitrator if they're seeking interim reliefs. Now, normally, in the course of business, if you want an interim relief as a party, you would have to go through the court system. But then we know how the courts are, even for an interim application. So that's what the emergency arbitrator is supposed to help you with, to give you an interim relief if you need one. The other issue is that of a pathological agreement. Now, the door through which parties are going to come to arbitration in the first place is through that agreement. But if you're a practitioner, you would have seen that a lot of the time you're going to come in contact with what we call midnight clauses. You know, somebody has copied something, pasted it, and the first course of business is trying to understand that clause. I mean, I'll give you an example. I had an issue where parties had an agreement to go to arbitration if the need arose, but the agreement was drafted to say if a dispute arose. Now, senior counsel on the other side drew my attention to say that there was no dispute, that what they had was a claim. So since it's a claim, we shouldn't be going to arbitration. And what's a claim? You know, he said, well, they're not arguing. You're owing us, yes. 200,000 naira, yes. There's no dispute. So I hope that by the end of today, we would, be a bit clearer on how to draft these arbitration clauses, and the fact that, it doesn't matter. As long as from that clause, you can infer that parties wanted to go to arbitration in the first place, then that's where we're going to go. So that I don't preempt the tribunal, we would go straight into the process now. Mr. Madumere, over to you, please.
Thank you so very much. Thank you very much. And welcome everyone to this tribunal sitting today, 24th day of October 2018. Now, following our appointment, and we have received some processes from council on both sides. But before we do the business of today, can we just announce our appearances, please? Madam Registrar, have you given them the sheet to write down their names? Okay. Please, can you please announce to the...
Thank you very much, Honorable Tribunal. My name is Jokba Otake. I'm representing the claimant in these proceedings, and with my colleague,
Osasiwa Edomwande.
Okay. Is the claimant represented other than you?
Yes, the claimant is represented.
What's the name of the representative? Okay. Okay. Yes.
Respectfully, Latif Yusuf. I am representing the respondent, and appearing with me, Emokinovo Dafe Akpedeye. Okay. We both represent the respondent in this matter.
Okay.
And
is the respondent also represented by...
The respondent is represented.
Okay. Okay. Now, before we go on to the business, let me also make this clarification, which is off record. Usually, you don't have a panel of 3 sitting as emergency arbitrator over an emergency proceedings. This is just, we are role-playing, and we thought it would be a lot more beneficial, to everyone, to have the benefit of the insights of, arbitrators. So usually, you have the appointing authority appoint a single person as a sole, over the emergency proceedings. So please, just imagine that it's just one person that is sitting before you, but with the benefit of 3 insight, the benefit of insight from 3 notable arbitrators. Now, that said, we were appointed to deal with the interim measure application from the claimant, but I'm also aware that we have received a notice of a preliminary objection from the respondent. So, and I'm just wondering, how would you want us to proceed? Would you want us to take yours first, or take theirs first, or take everything together? How would you want us to proceed?
We're hoping it can be combined to have both proceedings go concurrently. That's the jurisdiction and the application itself.
What is your reason for saying that?
We think that would be more effective. As the tribunal is aware, the reason for this application is the urgency involved and the impecuniosity to the claimant. The claimant is suffering losses on a daily basis on account of the actions of the respondent. So we think it would be better to save more time by combining both processes. The issue of jurisdiction naturally falls part of the issues that the tribunal will naturally consider in the course of considering the application itself. So there is really no reason to defer it. Okay.
What are your thoughts, Mr.?
Flowing from the doctrine of competence,
yes.
I'm of the view that once the jurisdiction of a tribunal has been challenged, the only thing that the tribunal should do as a matter of course is to halt every other thing and determine that jurisdiction one way or the other.
Okay.
So I will be disagreeing with my learned friend.
Okay.
And I would more opt for one, that's the jurisdictional challenge to be taken before the interim measures application by the claimant.
Okay. So how do you react to his views on procedural efficiency? Because he has said something about having a lot more efficient proceeding by combining the two. What are your thoughts on that?
Well, I'm more concerned about doing things right, because if at the end of the day, the tribunal rules that it has no jurisdiction, I believe, why go further? So we can take jurisdiction. We filed just 5 or 10 or I think 7 pages. So we could take that easily and have a decision one way or the other. Then we know our fate, instead of taking all in the basket and taking longer time. So I think our approach is more efficient, and time, it factors time as a consideration.
Thank you very much. Do you have any short reply? Just one or two sentences?
Just to add that there is nothing in the competence doctrine that indicates or compels the tribunal to take jurisdiction first. The tribunal can take it at any time it wants and still give an effective decision.
Thank you so very much for your submissions. If you could just give us 2 minutes, we will deliberate and give a ruling. So I will invite the tribunal member to please give the ruling.
The tribunal has decided, having heard both parties on this issue, to take both the applications together. Reason being that, first of all, for efficiency and for time consciousness, because this is supposed to be an emergency application, it's supposed to be an urgent application. So we shall take both together. And then if we decide that we do not have jurisdiction, then we can take the other aspect of the matter.
Thank you so very much. That presents the combined view of the tribunal, because if we find that we don't have jurisdiction, there won't be any need to go into the application for interim measures. So now we are aware that you had already filed your written addresses addressing the 2 core issues that you intend to raise. Could you confirm, starting from you, sir, that the papers we have represents the document you served? I have a document of 9 pages, signed by Mr. Jopa Otako, Osasowa Edowa, as counsel to claimant.
Yes, that's correct.
Do you confirm that represents a document? Yes. Okay. Sir, do you have a copy of this document with you?
I do.
All right. Now for you, sir, could you also confirm to me that document I have, which is of 7 pages, signed by Mr. Oluwaseun Philip Idiok and Latif Olagoke Yusuf and Madam Akbede, represents the document you filed before this tribunal, and represents the arguments you want to canvass?
That is the correct document.
All right. So have you received a copy of this document? Yes. Okay, and you've also joined us across the board?
We felt we could do that orally.
Okay, all right, wonderful. So, since a judicial challenge, we want to start with you, sir. You want to address the tribunal first.
Thank you very much for the opportunity, but
I'm going to give you not more than 10 minutes for oral adumbrration. Perhaps 10 minutes for you, 10 minutes for your colleague. Same for you too. All right.
My colleague shall be the one handling the jurisdictional challenge.
Okay.
At the office, we felt it should go that way naturally, so
Wonderful.
I would be deferring to her.
Wonderful. Please.
Good morning, good afternoon, Mr. Chairman and other members of the tribunal. On behalf of the respondent, we have filed a preliminary objection, objecting to the jurisdiction of this tribunal, and jurisdiction being a lifeblood issue, we believe it must be decided before any further action is taken in this regard. So particularly, we would like to refer to clause 15 of the software development agreement. If I may, Mr. Chairman, I would read the particular section. It states, any dispute, controversy, or claim arising out of or in connection to this agreement or the breach of it shall be settled by arbitration in Abuja under the Arbitration and Conciliation Act 2018. There will be 3 arbitrators, each to be appointed by the chairman of the Royal Institute of Chartered Arbitrators, London, Nigeria branch.
Yeah.
From this clause, we can see that this is a pathological clause, it is defective, invalid, and totally unenforceable. And we ask this tribunal to hold that it doesn't have jurisdiction due to the invalidity of this arbitration agreement. Mr. Chairman, you will note that there is no such institution as the Royal Institute of Chartered Arbitrators, London, Nigeria branch. It does not exist. In fact, this tribunal was appointed by the Chartered Institute of Arbitrators, UK, Nigeria branch. That is a totally different institution from that which was stated in the arbitration agreement. Mr. Chairman,
In our written brief, we have referred to a 2015 Court of Appeal decision, which is on all fours with this particular scenario. In that case, it was the president of the Chartered Institute of Arbitrators, London, Nigerian branch. And the Court of Appeal was very clear. You cannot make an agreement for the parties. The wording is clear and unambiguous, and it must be interpreted in a literal manner. And for that reason, the court held that there was no agreement to arbitrate. So, Mr. Speaker, Mr. Chairman, in this regard,
well, I might as well be a speaker, who knows?
we ask this tribunal to hold that this arbitration agreement is unenforceable. I would also like to refer to certain submissions made by my opposing counsel. They have referred to an Australian case. They have also referred to other Nigerian decisions. Mr. Chairman, these decisions cannot be followed. The Australian case is merely persuasive, and in a scenario where we have a binding Nigerian decision, and I note that clause 16 of this SDA refers to Nigerian law being the governing law, we must follow the Nigerian decision. In any case, the other Nigerian decisions cited are all pre-2015. So therefore, it follows that the 2015 case is superior in this regard. And so, Mr. Speaker, Mr. Chairman, we ask that this arbitration agreement be declared invalid. Finally, just to round off, Mr. Chairman, the fact that there was a notorious body known as the Chartered Institute of Arbitrators Nigeria already shows that there's an issue. Because even before the Federal High Court declared that that body should no longer operate, it could have been that the claimant could send a notice of arbitration to that body asking it to appoint arbitrators. So where would that leave us then, Mr. Chairman? It would mean that we don't know, is it this body or another body that should make that appointment? Because we have two parallel bodies running. And in any case, these bodies have nothing to do with the body of the Royal Institute of Chartered Arbitrators, which is stated in the arbitration agreement. So in conclusion, our case is a simple one. We ask this honorable tribunal to hold that it has no jurisdiction to determine this matter. Thank you very much.
Thank you so very much, Leonard Cancer. Yes, sir, could we have your response?
Yes, Ms. Edunwande Wood.
Okay.
Good afternoon, Chairman.
Is it on purpose that lady replies to lady?
Safer.
Good afternoon, Chairman and co-arbitrators. The respondent has rightly argued that the arbitration agreement is pathological because it refers to a non-existing arbitration appointing authority. While the claimants concede to that fact, we do state that the fact that the arbitration appointing authority is non-existent does not make the arbitration clause invalid. We base our submission on two grounds. The first ground is that the non-existence of an appointing authority in an arbitration agreement does not by itself render the entire agreement invalid. Our first case that we rely on is the case of Wands SA and Havik International Limited, which is in paragraph 15 of our submissions. So there we see that an agreement to arbitrate in which a forum that was stated does not exist does not then render the whole entire arbitration clause invalid. It would just be taken that the forum was not stated at all. So applying those facts to this case, because the Royal Institute of Chartered Arbitrators does not exist, we would therefore urge the tribunal to hold that we did not agree to appoint to an appointing authority. Our second case that I would like to refer to is also in our bundle. It's the Fidelity and Jimmy Rose case, where it was stated that once the parties have agreed to arbitration in a precise and unequivocal manner, the parties should then proceed to arbitration. In reading the arbitration agreement, we see that the parties agree that any dispute, controversy, or claim arising out of or in connection to this agreement or the breach of it shall be settled by arbitration. The word shall is decisive, it is unequivocal, it is precise, and it is clear. In another case, the Frontier Oil Limited case in paragraph 19 of the bundle, it was held that the use of the word shall is taken to be precise and mandatory and not permissive. It is different from the use of the word may. When the parties signed the arbitration agreement, the word that they signed to was shall, so they have that intention to arbitrate. Thirdly, I would also like to proceed to our second ground, which is that even if the clause is in fact pathological that we have agreed to, the parties can still remedy this by agreeing to arbitrate and signing a submission agreement. So in that case, the Dune Wind Farm and Alfred Markopine case, it was held that parties can have a clear intention to arbitrate, and by that get into a submission agreement that helps to remedy the pathological arbitration clause. So we urge the tribunal to disregard the objections of the respondents and hold that they in fact have jurisdiction to hear this matter and grant the relief that the claimant is seeking.
Thank you very much, madam. Do you want to give any reply?
If we may.
Okay.
Just on 2 points raised by my learned friend, she mentioned that the only issue with this agreement is that there's no agreement to an appointing authority. Even if that we can concede to that case, which we do not, it still raises an issue of jurisdiction for this particular tribunal. It means that this tribunal was not properly appointed by the Chartered Institute of Arbitrators because there is then no appointing authority within the arbitration agreement, and it was for parties to meet and decide how best to appoint this tribunal. So in any case, the tribunal will still not have jurisdiction. Now, the second point she also mentioned was that we could agree to a submission agreement. That's all very well and good, Mr. Chairman, but we haven't actually consented to a submission agreement. Again, it would mean that this particular tribunal is without jurisdiction because there's no submission agreement in writing, there's no signature by my client, the respondent, and therefore, we still hold the fact that this particular tribunal does not have the jurisdiction to determine this dispute, and parties should either refer to the Nigerian courts or meet at a later point to enter into a submission agreement. Thank you.
Thank you so very much. Now, we've already decided previously that we will take the 2 together and then give one ruling. So now that we've taken the first issue, can we then move on to the second issue, please?
Thank you very much, Mr. Chairman. The application before the tribunal is contained in our notice of arbitration already. We are seeking to restrain the respondent from proceeding with the development of an app known as the Evo Chat app. That app is being developed in breach of the software development agreement between the claimant and the respondent. We consider it very necessary for the respondent to be restrained or stopped from proceeding with this development because of the imminent breach of the agreement, and more importantly, the commercial survival of the claimant, as I would explain shortly. Now, the agreement, the software development agreement, which is part of the document before the tribunal, already contains the clauses to which the respondent agreed to in developing an app for the claimant. The claimant and the respondent entered this development agreement, and the agreement was for the respondent to design and develop an app known as the Beam app for the claimant. That app was developed, and part of the clauses that the respondent signed up to as contained in the agreement.
The non-compete clause.
If the tribunal permits me, I would like to read the non-compete clause, clause 8 of the agreement. It says that in consideration of the payment made by the customer, that is the claimant, to the developer in this agreement, the developer agrees not to develop, design, code, test, or document a competing product. The developer covenants and agrees that it has no right to market, distribute, sell, or license any of the applications or deliverables being developed under this agreement. Additionally, the developer covenants and agrees that without the prior written consent of the customer, that is the claimant again, it will not enter into any discussions with any party with respect to the foregoing applications and deliverables for a period commencing on the date of this agreement. I would stop there. Now, it means that the respondent has a contractual obligation not to even discuss the production or development of any competing app during the subsistence of the software development agreement with the claimant. It turns out this respondent went on to not just discuss, but actually develop a competing app, an app known as the EvoChat app for a known competitor of the claimant. And that's why this application is necessary. Before proceeding, it's important to take the tribunal through some fundamentals. The governing law for this reference has been stipulated by the parties in the arbitration agreement as the Arbitration and Conciliation Act 2018. And that law empowers this tribunal to consider and grant interim applications of this nature. What are the grounds for such an application? The law is pretty silent on it, but international standards and international authorities are unanimous on the criteria that should govern such an application. One of it is that the claimant should have, or the applicant should have, an arguable case on the merits. I've already taken the tribunal through the merits of this application. If the tribunal considers the two apps in question, the app designed for the claimant and the app which the respondent is in the process of designing or developing for the claimant's competitor, the tribunal will notice that both apps are functionally similar. Both apps are targeted at the same population range. Both apps are to create a digital platform for virtual interaction between this same population range. It's mainly young people who use apps like this, and that is the target audience for both apps. More importantly, both apps allow brand participation, allow brands to advertise and sell their wares through the app. Essentially the same app for two different rival companies. The respondent will want this tribunal to believe that both apps are different or they do different things, but looking at the clause I just read out, it's clear that at the time of this agreement, the parties were not agreeing that the respondent would not design the same app for another company. They were agreeing that the respondent will not design an app that is capable of competing with the BEAM app. The question is whether this app is capable of competing with the BEAM app. The claimant's submission is that it is capable of competing, and it is actually competing with the BEAM app. It's targeted at the same subscribers that the BEAM app was created for, and the intention can only be that it is intended to undermine the success of the BEAM app in the market. That's the case of the claimant on the merits, and would lead evidence on all this in the substantive proceedings. But for now, the important thing is, should we allow the respondent to go ahead with this development, put this app out there in the market, and stand the risk of having a rival app in the market before these proceedings are concluded? That's the dilemma that the claimant faced and necessitated this application. My colleague has already dealt with the issue of jurisdiction, but it's important to just reiterate that the jurisdiction of this tribunal to deal with this interim application is not conclusive. It's not for this tribunal to conclusively determine whether it has jurisdiction or it has no jurisdiction. All this tribunal needs to be satisfied with is just a preliminary inquiry as to jurisdiction. Is there an agreement to arbitrate? There is clearly an agreement to arbitrate. Clause 8 of the agreement contains, clause 15, contains an arbitration agreement to the effect that any dispute arising from this agreement shall be settled by arbitration. The question of how the arbitrator is a question for the substantive arbitration proceedings. It's not a question at this stage. So at this stage, all this tribunal needs to be satisfied with is that there is an agreement to arbitrate. Protect the subject matter of this dispute pending that arbitration. this tribunal needs to be concerned with as per jurisdiction is the power to grant the application. And that power is already conferred in the governing law chosen by the parties, the ACA. Section 20 already empowers this tribunal to protect the status quo, maintain the status quo of these proceedings. And that's what the claimant is asking for. The most important consideration at this stage is...
3 more minutes.
Thank you very much. The most important consideration is the risk that the claimant faces. The risk that the claimant faces is that if this respondent is not stopped from putting out this app or designing this app, the claimant would have a rival app in the market. The claimant's commercial prospects for the BEAM app that has just been developed at great cost and has also been subjected to significant marketing. Millions of dollars have been spent with external marketers for the purpose of this app. All of that will be gone if this rival app is allowed entry into the market. In fact, the mere rumor of this rival app has already caused ripples in the market. At the point before this proceeding started, before this rumor came up, the claimant already had over 1 million subscribers to the BEAM app. Since the news of the respondent's new app for the claimant rival came up, subscribers, the claimant barely gets up to 100 subscribers in a day. So it's a question of the claimant's survival, the claimant's commercial survival. The respondent has this argument that the app that they have created for the claimant, for the rival company, is a different app entirely. And that means that the respondent has nothing to lose. Because if this application is granted, and at the end of the proceedings, this tribunal agrees with the respondent that that app is different, then that means there is no competition. That means that the claimant, the respondent's app can come into the market at any time without interrupting the BEAM app. But if it is false, if it is true that both apps are actually identical, then it will be putting the claimant in a very, very peculiar situation, because that means the claimant will be subjected to competition that it ought not to have in the first place. A competitive app that is made by the same respondent who would have had the opportunity to improve on whatever has been wrong with the first app it made.
1 minute more.
Thank you very much. I'm rounding up already. And so the tribunal is faced with these competing choices. What is the risk to the respondent? The only risk the respondent faces is contractual issues with the rival company that it has entered agreements with to create a rival app. That can be quantifiable in damages. Unlike the claimants who will be faced with not just exposure in terms of investments made in this new app, brands have already paid the claimants to advertise on this new app. Those brands are already developing cold feet. No more brands are coming up to invest in this app because they are ahead of this new app and they've started showing interest in the new app already. So it's important to stop this new app from going out there to ensure that the claimant's investment in the BEAM app is not lost. More importantly, the claimant has already committed to covering the cost of this emergency proceedings. So again, there is no loss, no risk, nothing to the respondents in terms of pecuniosity at all.
Time
the
up.
claimant bears all the risk. Thank you very much. So we're urging the tribunal to grant this application.
Thank you so very much, sir. Now, could I have your thoughts on it?
Thank you very much. Before I go on to make my submission, I must say very carefully that the new trend in arbitration, especially international arbitration, is to cap cost. So I'm still going to go back to that point at the tail end of my submission. Now, the claimant counsel is actually my friend.
Sorry, could I take you on that, please? Capping costs in what context?
No, I'm not really talking about capping cost in terms of putting a fixed ceiling ab initio, but the tribunal must have cost in mind at the very onset and think far into it. So they don't go on a journey that will just allow cost to flow like a stream. That is my point.
Thank you for your consideration.
Now, the claimant said something and I find it very, very interesting. He said both apps create digital interaction between people and all that. He was trying to justify that they are the same. And I'm like, every social media app creates interaction between two people. That's what Facebook does. That's what Google does. That's what everybody is into. That is what is in this business. In fact, it might shock the claimant that Apple computers actually source their touch screen from Samsung, and nobody's in court. So it depends on the specification. Now, specifically into this dispute, respectfully, the claimant counsel said they have the same subscriber base. That cannot be true. We are the developers. We developed an app called Beam. Beam targets Generation Z. I'm talking about people between the age of 13 to 28. Now, this app connects this peculiar generation to tailor-made brands. What do 13-year-olds to 28-year-olds need? They need phones, they need sneakers, they need things that maybe in the next 10 years, when they outgrow that bracket, they'll be like, these things, I don't really need them anymore. Now, the other app that we designed for CIArb, that app connects homeowners to specific things that they need in their home. And we're talking about middle-aged people from 30 to like 60. Now, going forward, he made a very powerful submission on what do we have to lose. He said, we can just lose maybe whatever we contractually signed with CIArb. And I must say something as a precursor before I make a particular submission. The question now is, all the algorithms, all the codes, and all the technology that we used in developing Beam were signature technology. That means there is no other company that can copy it. They are all encrypted. Now, CIArb, we used a similar custom-made algorithm coding system to design their product. Now the question is this. There's a reason why they call the industry Silicon Valley. Because in a valley, everything you say echoes and words go around. The problem now is, we are into only one business, that is software development. That's all we do. We don't do any other thing. And we are the leader because we have mastered the AI technology and we use it effectively. Now the question is, they just come, they get a patent and they call us, come and develop this thing for us as other people do. We do only one thing. The question now is, CIArb, they've already committed over $1 million into developing EvoChat. Now, EvoChat is an app that has not even launched. And the claimant is already claiming that something that has not launched and gotten into market is already competing against them. Now, furthermore, the claimant is now hinging this their application, because I see it as an application to witch hunt the respondent for taking up a job. In fact, the only similarity between the two apps is the fact that we designed both. That's the only similarity. We are the developer for both apps. Now, the question now is this. What can the claimant really lose versus the respondent? We are going to lose our existence. If this interim measure is granted, this is what will happen, and I'm going to state it chronologically. 1, no other developer can continue the project that they've already committed $1 million to, because all the algorithms and the codes are signature codes encrypted. And we will not release the encryption code to anybody, because that is our DNA, that's our survivor. Now the question is, the CIArb will have to start all over again and get another developer. If that happens and you lose $1 million in Silicon Valley because of a silly developer, the question is, you will never get another job. Nobody will take you on. That's 1. 2, we have royalties embedded in this contract with CIArb. So they are saying you just lose. What if EvoChat becomes successful, like Facebook tomorrow? We get royalties. So you can't even quantify what we'll lose in royalties. We have after-service clause in the contract with CIArb. That means after the development of the app, if it functions properly, we are the only exclusive company that does servicing for them. So we lose that too. Now finally, which is like the most serious out of everything, we lose ourselves in this process. We get no job, we cease to exist. What we are going to lose can never be quantified. In fact, I have it on good authority that if this application does not go our way, the respondent is willing to challenge the whole decision of this tribunal.
Is that part of the argument too? Should that be part of the argument at this stage?
I think.
I'm just wondering if that's a guerrilla tactics or something.
I'm coming to the issue of looking at costs. I must be able to bring to the attention of the tribunal.
Are you taking back the comment
3
you made
minutes
earlier?
more.
It is within your rights to challenge, but I don't think we need to educate us on that point at this stage, please. Do you want to take that statement back?
Okay, since the statement has already had its effect, maybe it could it could be expunged for educational purpose. We could expunge it, but at least it's been heard. So
no, now let's have an interlude at this point. That comment was pointless, really, because it sets him up against the tribunal. Yeah. And the effect is actually to twist us to do what. Yeah, but it's going it will re-echo against him. So it's not something you should do in practice, as a matter of fact. And I believe he knows.
Yes, we do. Right. Just for the purpose of learning.
Yeah.
Finally, this is the moment where we have to face what is about to happen. We have a company that already has a pre-subscriber base of 1 million subscribers. We have another company that has not even launched. Now, they've brought an application to stop something that has cost so much on interim level. I believe an interim measure cannot adequately take care of the peculiarity of what is at stake here. Because in the main arbitration, we are prepared to bring diagrams, we are prepared to bring experts that would share with the main arbitrators the peculiarities and the differences that are inherent in both products. So there is really nothing that anybody can come here and feel that we can solve on interim level. So it would be great injustice to stop or to give an order against the respondent on interim level, because we would not have been given an opportunity to fairly present our whole case. Because in the main arbitration, we have over 15... How many more minutes, please?
Less 56 seconds.
In the main arbitration, we have over 15 Chinese AI specialists that would educate the tribunal on the differences between the two apps. So I'm urging this tribunal to quickly abort this very suicidal mission, so that we can go for the main arbitration as quickly as possible and we don't waste further cost. Thank you very much.
Thank you so very much, Honorable Counsel. I personally, I think I want to have you as counsel in real life, really. Address me on an arbitration. So I'm sure you want to make some comments.
Yes, thank you very much, Mr. Chairman. Listening to Mr. Yusuf, one will be forgiven to think that he is acting for AR Labs, our competitor, and not for Sinosoft, the designer of these apps.
We're together.
The only thing, and the tribunal should note that that is the concern of the claimant here, that a competitor of the claimant is about to be equipped unfairly against the claimant. And it's playing out already in the proceedings. We could see that the respondent's counsel seems to be more interested in what our competitor would lose rather than what the respondent itself would lose. And that's very important, because the narrative as to how much AR Labs has invested is of no relevance whatsoever to these proceedings. The issue here is what the claimant stands to lose if this competing app is allowed into the market. Mr. Yusuf has not addressed the fact that he has made so much weather as to the fact that it's common for apps to have similar functions or to be directed at similar users. But he has not addressed the elephant in the room, which is that the respondent had a contractual obligation not to do this. He cannot be interrupting you.
Which we carried out. We carried it
Cannot
out.
be
We
interrupted.
carried it out.
Sir, can we please have some order in the room, please? Go ahead, yeah.
He has not addressed the fact that his client had an obligation not to do this. It's not just about the fact that apps are normally for the same users. It's whether are you allowed to do what you have done. Do they have an obligation not to do this? There is a reason why there is a non-compete clause in the agreement that they signed. And in spite of that, they have done this, and they want this tribunal to allow this to go on in the hope that they will call some 15 witnesses. It's almost as though they are planning to drag the substantive proceedings so that the damage will be done. So that the damage will be done before the proceedings are even over. He called it a valley, and that may be right, even though the valley is very far from here. But that may be right in the sense that in this valley, customer sentiment is very fickle. People move from one product to the other in the blink of an eye. And it's no surprise when he says that we already have 1 million subscribers. It's like counting subscribers that are practically dormant now because everybody is waiting for this new app that is about to be released. It's all over the place. And that is what the claimant is apprehensive about. Money has already been invested in the Beam app. That money has not even been recovered. And now the Beam app is about to be subjected to becoming yesterday's world, simply because the respondent cannot honor simple contractual obligations. That's what this application is all about. And thankfully, the respondent has not given this tribunal any reason to act otherwise. It's important for the tribunal to ensure that the claimant's interests are adequately protected in granting this
10
application.
seconds, please.
Thank you very much.
Thank you so very much, Counsel on both sides. You have given very useful insights to the tribunal. We will now retire for 5 minutes and then reconvene to give our ruling on the two issues. But before we retire, I want you to pay particular attention to the conduct of Mr. Yusuf. I'm sure that is not the way he conducts himself in court. We're just role-playing. Every typical Nigerian lawyer you see in international arbitration tends to put up that kind of show. That is needless. Completely needless. This is a very friendly process and very civilized process. You could still make your point with some measure of courage. Because if an Englishman sits before you and you're conducting yourself like that, you're already -5. Because he sees you as aggressive. So when you conduct international arbitration proceedings, put off this hat of a typical Nigerian lawyer, litigation, thank you very much, litigation lawyer, and then have some measure of, that's why training is important. And that's what we do in this institute. So thank you so very much for acting this role so very well. So considering the fact that this room is very hot, we will take a 5 minutes break, then deliberate and come back. Thank you. Yes. Yeah.
While the tribunal is deliberating, any observations? Well, first of all, you have seen what not to do.
Let them note their observations. Let them note. Once we read, then we continue.
So, note your observations. Go on to Slido. Questions. When the tribunal gives their ruling, they will answer whatever questions you have. So it will be good to post them now.
Number one, it's very obvious that there's an intention to arbitrate from the clause. The language is very clear. Parties have already intended to arbitrate. It's very clear from the clause. And so there's no doubt about that at all. And then the mistake in couching it, chairman of whatever. No, I think it's this one. This one, clause 15, where they said chairman of the Royal Institute. Apparently, how many do you have? It should be more than 5. Okay. Okay, yeah. Now, madam, from clause 15, we said it's obvious parties have intention to arbitrate. There's no doubt about that. But, and this one is a non-existent body. So it's not as if they described the body wrongly. It doesn't even exist at all. So apparently what this man said is correct. Exactly. There is, and the fact
That's
is that...
the modern trend now.
Yeah. So...
In fact, apart from the Mekunye case, the Nigerian case, the world has moved on.
Yeah. So once you have identified intention to arbitrate, the tribunal must try to preserve that intention, allowing parties to arbitrate. So as it is now, the appointing authority is now clearly set out. And so that is it. How do we go around that now?
Hello. Well, if you haven't registered, has everyone in here registered? At the registration desk, attendance sheet. Do you have your details on there, everyone in the room? Okay, so parties exchange pleadings, so those will be sent to you later on after the conference. And the ruling. Why is only one person clapping? I feel much better now.
I guess based on the points that we raised. Exactly, that's true. Are you coming for the remaining 2 days? No. Too much work. How's Bunyamin? I had class with him at the LCA. No, I just did it last year. Really? What's her name? Was she, was she married? Does she have a previous surname? Because I know Damlola's there, who's married to Damlola. But I can try to remember her first surname before she got married. I don't know her new name.
I don't know that she's very possible. So when you first met, so that's what I was saying.
And that was even at Alex. So
I saw her at Alex.
Okay.
And then I was not talking to her as usual.
Who's in the course?
Like, what are you talking about? I said, see one. She said, no, to see one.
Wow, that's interesting.
So now that you mentioned Benjamin, I now remember because I was at the LCA when Benjamin went to do
Okay. Did you ever work in the Lagos office?
No, but I do a lot. Most of my work is actually in Lagos.
So you come to Lagos, so you just stay here. Oh, okay, that's good. You don't want to just stay in Lagos, no.
I'm not sure I want to do it in my Lagos office.
Okay.
But I do, like, actually do more of Lagos work than Abuja work.
Really? Oh, what church is that? Oh, in Abuja. Okay, my parents go to Koi Baptist. That's where I grew up.
Yeah, interesting. That's so. Why are you not? Why are you not still there?
I left there since I schooled outside Nigeria.
Even outside Nigeria, whenever I'm outside Nigeria.
When I was outside Nigeria, so I went to Catholic University anyway, but I didn't become Catholic. So my parents used to me, they were wondering why I'm not looking for the Baptist. And I'm like,
Actually,
as long as they're preaching Jesus.
I find it in the UK, the church I sent you anytime.
Really? Okay, when I was in England, I went to Hilton.
Oh,
when I was in New York.
I wanted to go for it because I had a friend who was always telling me about it. Anytime I go there, and they're always very good people in the church, but I just enjoy it.
It's quite traditional. You know what you're going to
Very
get.
conservative.
My parents' church, they have a new pastor. They had a pastor for 25 years, conservative, didn't speak in tongues. Now they got a new pastor, and
Yeah, it's trash from
they
them.
want to send him away.
Oh, they want to use.
It's so funny. Mrs. Ali goes there. You know Mrs. Ali? With the conference planning chair.
Yeah, I know her.
She goes there as well. There are quite a few lawyers. The partner in.
Yeah, it's
Yeah,
Tola
but
should be
yeah,
used to.
yeah. So he doesn't go to that one. I go to the Lexi Baptist Church, which came out of it.
Oh, okay. Because he's also
I hear
very
all
conservative.
the I hear all the, and I find it interesting. Yeah.
Maybe Baptist Church is very conservative. In fact, it was been the last 10 years that the Abuja Church, that's the First Baptist Church of Abuja,
Yeah, I know.
that's when it eclipsed the Ikoyi Baptist Church. The Ikoyi Baptist Church was always like number one Baptist. I've never been there.
You haven't? Oh wow.
I've heard so
Yeah,
much about it.
they even got a whole new building. Really nice. Next to the old one. A lot of the
People in my
members.
church
Yes.
here always say
Because
that when
those
we're
who
in
moved,
Lagos, we're in
yes, those who moved from Lagos to Abuja go to.
Photo.
Yeah. It's a nice family.
And a lot of people, the moment they leave their parents, they seem to just leave it. I don't like, I consider myself a bit of a conservative as well, so I don't
Yeah.
like noise and too much gymnastics in church.
That's when the spirit is flowing.
I hear it.
That's how the former pastor was. Very conservative. And the thing is, that means they're like an old person because that's all old people like. They don't like surprises.
I would say I don't like surprises, but more like I don't like.
The new pastor, he can just be preaching and next thing. It's so fantastic when they come back from Sudan, they're just like, what happened today? And I'm like, yes, good.
Like my pastor, like my church, my pastor is of the old block. But
Yeah.
I wouldn't consider him outrightly conservative. In fact, the Baptist history,
Probably one of
he's
the
part of
less
people who were
conservative ones.
the revolutionists of some sort. Because the Baptist church I grew up, growing up in the Baptist churches didn't used to do night vigils before.
Oh.
Yeah, they never used to do night.
Really?
It was a policy.
Yeah.
They didn't, of course, speaking in tongues is just one of it. But there's
Night
many
vigil, I
things
know, we can't
Baptist
sleep in
churches
church.
don't do. They don't sleep in church. They don't. So the day in my church then in Lagos, though, I was staying in First Stack then. The day my mom used to be part of some
Women's group,
the
WMS.
revolutionists in the church then. So they planned in that group that they were going to have a vigil with or without the pastor. They were going to have a vigil. And when they got to the church, the pastor had locked the church. He locked it with a key.
They had it outside.
Exactly, they had to have it outside.
I know those kind of people.
They had it outside. But eventually, of course, the church had evolved. Baptist church resisted a lot of things. That
All right, go call the sitting to order now. I'm sure you had nice refreshments. Even though the YMG denied us water, denied us sweets and biscuits. No problem. We are ready now to, to convey our decision on the two issues canvassed by parties. Firstly, I will invite the emergency arbitrator, to my left to give our views on issue of jurisdiction. Please.
Okay, thank you, Mr. Chairman. On the issue of jurisdiction, you all heard the argument of the respondent who raised the preliminary objection that we do not have jurisdiction because we are not appointed by the correct institute, so to say. And you also heard the response of the applicant counsel that based his respond mostly on the fact that there is an intention to arbitrate. We have considered all the issues raised by both parties, and it is a considered opinion of this panel that the claimant is the one that we are following. We are rejecting the preliminary objection raised by the respondent, and our order is that the arbitration, that we have jurisdiction to proceed, and that the arbitration will go on for the following reasons. The main reason, really, everything goes around that particular reason, that there is obviously an intention by both parties to arbitrate. And for us, we think that that is the major thing that we should be looking at this moment. It is true that they didn't use the correct words. I know in the paragraph that referred to a non-existent body, so to say. It's not really in existence, but the fact is that they have, without any doubt, shown that they want to arbitrate. And in the modern world, things are really, really moved on. The world has moved on beyond the decision in Mekunye's case that we're always talking about. That case didn't really explore some other things that we expected them to do, but so be it. The world has moved on, and with the recent practice direction that the CJN has given to the judges to always uphold arbitration clauses and all that, we have decided to follow the recent decisions of other jurisdictions, more so because of the difference between the law, 1988 law, which states particularly that you follow the law, as compared to what we have now, 2018 law, which hopefully we hope will be passed. It talks about following the rule of law. So in stricto sensu, we are not bound by the decision had been taken before in the Mekunye case. We can now look outside, and see what is going on in the entire world. And we quoted there are some cases that they referred to. I've written some of them here, but in particular, the Australian case that he referred to it, Bozimo referred to it so many times, that there are certain criteria of things that you now look out for when you have such situations. You want to find out whether there's an intention to arbitrate, and then whether there's a framework, a legal framework. In this particular case, they refer to the Nigerian law. So there's a framework. And also, let me see. The name of the case is, in particular, the name of the case is I'm not wearing my glasses. Robotunis Property Limited versus Menal something V versus SC 268. It's an Australian case anyway. The conditions that were laid down by the honorable judge, and that which is really going viral in the entire world, people are following it, is what is the matter for determination in the proceeding. That one has been settled here. It's about non-compete provision, that is what they're quarreling about, whether they should have entered into another agreement with somebody else when they had a non-compete provision. And then the second one here is the matter within the scope of the arbitration agreement. Of course it is. That is the basis for the agreement. And then the third one here is the matter capable of settlement by arbitration. It is an arbitrable matter, and most importantly, there's a structure on ground already for the, for the enforcement of whatever decision has been taken. So that is the decision we have taken.
Thank you so very much.
We are upholding our jurisdiction, which we have a right to uphold. We are upholding our jurisdiction to go ahead and look into the matter.
Thank you so very much, Madam Arbitrator. And let me just, recap what she has said, and let me make, a tweak a little bit. In arbitration, as a matter of language and as a matter of practice, we don't say what they say in court. We don't give considered opinions in arbitration. An opinion is an advice. We give judgment. In our judgment, it is our decision. In our judgment, so and so and so. In our judgment, we have come to the conclusion that we have jurisdiction. And reasons she has outlined. Number one, we have found in the clause clear intention by parties to arbitrate. So we are inclined to upholding that intention by sustaining our jurisdiction. Yes, the appointing authority was wrongly, set out. But we are inclined, because from the point she made, we are inclined to upholding that jurisdiction because we are not really bound by the Mekuna case he referred to, the Court of Appeal decision. If you look at the ACA, Section 23 ACA says the tribunal will decide according to the applicable law. But the revised version of the model law, which is the 2018 one, talks about applicable rules of law. And rules of law are a lot more expansive. Rules of law allows you to draw inspiration from other jurisdictions outside of the country, outside of the seat. So there's an attempt to internationalize arbitration practice. So we are not bound by the authority that you cited. So on that basis, we are come to the conclusion that we have jurisdiction. Can I then invite the Madam Emergency Arbitrator to my right to give our decision on interim measure?
Having listened to the arguments canvassed by both parties, we have decided that there is no doubt that there is a non-complete clause. The effect is that the claimant has a right to preserve the exclusivity of the BEAM software. I am satisfied on a prima facie basis that there is a non-complete clause and that there is harm that may be irreparable if the application is not granted. This tribunal will not go into the similarities of the two apps as argued by the counsels in this matter. We shall leave that to the tribunal that will be constituted. I note that the fact that the claimant has given an undertaking in damages, therefore this tribunal is here to maintain the status quo until a proper tribunal is constituted. Where the main tribunal finds that this order should not have been made, the tribunal may reverse the order and award damages against the claimant. I therefore make the interim order that the application of the claimant be granted.
That is the language of an arbitrator. That is the language of an arbitrator. That is the way it should be said. Yeah? So we are now open to take your questions. If there are any questions you want to ask, perhaps through Slido or perhaps by a raise of hand. Do you have questions on the system already?
No.
So do you have any questions you want to ask me by a raise of hand? Okay. Madam, take charge.
So we're taking 5 questions only. So if you want to ask any questions, just raise your hand. Okay, so 1, 2, 3, 4, 5. Okay. So we'll start from the gentleman at the back.
Take the questions so you can answer some.
Thank you.
Please, your question should not be more than 1 minute.
Okay, 2 questions, quick ones. My name is Sifas. So my first question has been addressed. I just wanted to clarify the extent in which a tribunal can go beyond the arguments of parties to take a decision. Because based on the argument, I agree with the respondent that the arguments of the claimant conceded on the issue of jurisdiction because he said there is no submission agreement and there is no appointing authority. That's actually conceding that. But I see that the tribunal has gone beyond that argument. And that was my question. To what extent can you go beyond the argument of the parties to make that decision? Then the other issue is the argument of the respondent. They kept arguing that once there is the issue of jurisdiction, the tribunal should entertain it. I understand that that applies to court, but I don't know to what extent that, is it really the thing that once it's jurisdiction, you must hear it first before you must decide on it? Thank you.
Can we take all the questions first? Okay.
Take all the questions.
Can you give him the microphone? Thank you.
Good afternoon. I am Lamar Gadzama from the Canada International Center for Arbitration and Mediation. I have a question to ask regarding fees. Do the parties pay the emergency arbitrators any fee, or is it free? Thank you.
No, the ICC collects the money.
Good afternoon.
even if it's ad hoc.
Good afternoon.
You
I
ask
am
him to
Maton.
deposit.
While he was not the best example to follow, I think he raised an interesting point that I thought of. A third-party opinion is not supposed to influence the judgment of the panel, but shouldn't it, come in as a reasonable argument for cost? Wouldn't the judgment, like he was trying to put in that the third party wants to sue against the judgment that or decision that is arrived at. I'm saying, shouldn't it to some extent, have an influence when the parties discuss cost?
Thank you. Good afternoon. My name is Laura Lakija. So my question is, I see that what we dealt with today was a pathological clause, and the tribunal was able to go beyond that defect in the clause to look at the intentions of the parties in reaching their decision. So what I want to understand is, how far can a tribunal go? How far can a tribunal go in looking at the intentions of a party to be able to make a decision in spite of a pathological clause or in spite of a pathological arbitration clause? I don't know if you understand the question, but that's my question.
Down, excuse me here.
Good afternoon. My name is Chizara Muzodima, and my question arises from the oral submission. I would like to know whether an aggressive counsel can negatively affect the merits of the arbitral tribunal's award, especially where the counsel's case is very convincing. And if no, then what exactly is the effect or the impact of having an aggressive counsel making oral submissions? Then secondly, would it not amount to the arbitral tribunal acting outside this jurisdiction if it applies cases, foreign cases, where the agreement specially says that the arbitral agreement is governed by Nigerian law? Would it not amount to acting in excess of its jurisdiction if it applies foreign law in reaching its conclusion? Thank you.
Are we done now?
Yes, thank you very much.
Okay. Thank you so very much for the questions that you have posed. I will take question one. Which one will you want to answer?
Take question 2 and 1.
No, she has taken 2.
Okay, she has.
You want to take 1 and 2? One. Go ahead and take 1.
Okay. The extent to which tribunal will go to make a decision.
She will take 2. So you want to take 1? Does anyone want to take it?
Aggressive counsel.
You take that? Which one do you want to take?
It's okay. Okay, I'll go for the last question. If I understand her rightly, she says something about the effect of a counsel being aggressive on the decision of the tribunal. Is it on the decision of the tribunal? No. Okay, on oral argument. Well, I don't think, even in courts, there's a way you can behave in court and you set yourself up against the judge, depending on the type of judge. Some judges will correct you and, in fact, try to disgrace you. It's as simple as that, depending on how strict they are. So I don't think it's a good thing for any counsel in any situation to try to set themselves up against whoever they are appearing before. Because, this tribunal has the right to decide this matter, and you're trying to be very, very aggressive and disrespectful. Most of the time, aggression goes with disrespect. And, talking about human relations and all that, you want to be a good counsel before a judge, before the tribunal, so that they will even hear you. Some people, when you become very aggressive and disrespectful, they switch off. They won't even hear the points they are making. Some of you that go to court, you will notice that sometimes when you're talking, the judge is just looking at you. They are not noting what you're saying, and you can't go on appeal if the judge has not captured the point you're making. I guess the same goes for the arbitration tribunal. It's not in anybody's best interest for the counsel, either the counsel or your client. In fact, it's your client that you're doing most of the disfavor, and also yourself, because you're destroying your own reputation. Once you're known to be that kind of counsel, you'll be surprised that the word goes round, and whoever you appear before will have some, reservations about you. I think you raised another issue. Second question. Sorry, is it in respect of the same? Okay.
You said if they say Nigerian law should apply.
Okay, if they say Nigerian law should apply.
Of your jurisdiction.
Well, I think the chairman had taken care of that particular issue, that in the old law it says the law. But in any case, every arbitration is sort of different. We don't really, I'm not aware that we have a precedence in arbitration. We don't. There's nothing like that, unlike the cases will go with the Court of Appeals decision and, up to the arbitration from my knowledge, but, following any particular order. But more so because of the change and the difference in the new law that now widens the horizon and gives us the opportunity to go outside. But even in law, most of the time where there's a particular issue that is coming up and it's a bit sensitive, a lot of times judges still go outside to see how that particular issue had been treated in other jurisdictions, and they may borrow or decide to follow that line of, argument.
Usually the appointing authority in liaison with the arguments that go beyond those canvas the parties. Well, I'm not sure the gentleman over there listened very attentively to the argument of counsel to the claimant. Virtually everything that we had decided, we drew from the arguments parties had canvassed. And everything we said about intention, he actually said. It's not usual for you to, just like, in arbitration, that's what they call the mandatory provisions of the law. And those provisions requires that you must decide, you must give parties opportunity of having their insights on all the issues that will affect your decision. So it's not possible for you to decide on your own evidence, on your own persuasions, without giving them the benefit of having their insights and their perspectives. So everything we said in arriving at our decision, we had drawn from what they canvassed. So it's not done really. You can't decide based on your own evidence. It's not done at all. Even if you have views on the subject matters before you should ask them to address you, on those points. And then also, let my colleague take the one on fees, and then we'll continue from there.
Okay, I think a gentleman asked something about who pays the emergency arbitrator or whether his services are free. Well, unfortunately, nothing comes free. The emergency arbitrator must be paid, and obviously it is the parties that will pay. This is a role play, and we spent an hour here already. So you can imagine if it was real life. Sometimes emergency arbitrators spend as much as 3-4 hours, depending on the complexity of the case, how long the arguments are. And if you're familiar with institutional arbitration, you will see that if it's the ICC, for instance, or the LCIA, or depending on the institution, some of them charge per hour. Or how complex. So regardless of whether it's an emergency arbitrator or a proper tribunal, arbitrators are always paid. Okay? And it is the parties that will pay. Okay, she wants to deal with number 2.
So now we'll go on to number. You want to say something? Number 3. Okay. We'll go on to question 3, which says, to what extent, I think the gentleman over here asked that question, whether it is proper to take into account third-party opinion. I'm not quite sure that was what he actually meant. What he tried to do, if I understood Mr. Yusuf very well, was to expand the reasons why the tribunal should not grant interim measure. That its effect will have far-reaching implication on a non-party, who is the other app owner. So I'm not quite sure you got it correctly when you said third-party opinion. He wasn't canvassing a third-party opinion. He was only saying the effect of the interim measure, if granted, could have far-reaching effect on a non-party. And it was in his right to say so. If he felt that was adding straight to his argument, why not? Yeah?
Do you want me to talk about the jurisdictional issue?
Oh, please go ahead.
Okay, on the second question that I have here, it says once jurisdiction is mentioned, you must decide on it. It's not true. That is not the situation of the law as it is now. No, you can deal with it first of all. Because if you don't have jurisdiction, that will be the end of the matter. But a lot of arbitrators also deal with it on merit. You have the power to deal with jurisdiction on merit. That is, deliver your award the same time you're talking about jurisdiction, the same time you're talking about the merits of the case. So it's not mandatory that you must deal with it first. That is not the situation of the law as regards arbitration.
Okay, the last question we have here is, to what extent, I think the lady over there asked that question, to what extent is it permissible for the tribunal to look at the intention of the parties in construing a pathological clause? Now, okay, the lady over there asked the question, yeah? So now, the simple answer is that the trend globally is for tribunals and courts to, as much as possible, try to sustain the agreement to arbitrate as far as it's sustainable. And you can only look, decipher the intent from the words used. You recall the gentleman over here kept mentioning the word shall. No, the lady. She kept mentioning the word shall. Which is, and if you look at the clause really, there is no doubt about it that the parties had actually intended for the dispute to be resolved by arbitration. So to that extent, tribunals are encouraged and courts are encouraged to sustain the life of that clause. Okay, and you can get that intention from the statement or the clause itself. Yeah, and then the next thing I want to just add my voice to the answer given by my colleague over here is the extent to which aggressiveness can affect the way the tribunal perceives your case. Now you know that from experience as lawyers and non-lawyers that regardless of how good your case is, no case is 100% foolproof. No case. There is none. That is why people always have things to say. So you want to, as much as possible, cut the favor and the kindness of the tribunal by being civil towards them. East African lawyers, Mr. Arbitrator, they are addressing you in a very civil way. You don't want to be aggressive. Once they perceive you as being aggressive, regardless of how good your case is, when it comes to 50-50 situations, they will just, swing it against you. So you want to be very polite, very civil, but very firm. Very firm, very, very firm. Tribunals are very impressed when lawyers are very firm on their convictions, and it shows that you know what you're saying. You saw the way Madam Arbitrator was, reeling out her orders. That gives the impression that you're on top of your craft, So with that, I believe we have come to the end of this sitting. Our invoice is ready. Who said our invoice?
We have to be paid now.
Just to answer what the gentleman asked, whether it is for free. It's not for free. Our invoice is ready, and we'll pass our invoice on to YMG. Right.
I just wanted to add briefly that during rehearsals in the morning, we actually sought the permission of the arbitrators to present a very aggressive version so that they can actually jump in on, and it can give everybody an opportunity to actually learn what not to do.
Yeah.
So this is not how I. This is not how I.
This is not your modus operandi.
So. All right. One house. I bear testimony to the fact that we had actually agreed, for him to, conduct himself in that way. And I believe my gentleman here can corroborate that fact too. Yeah. Yes. All right. So long. Thank you very much.
Ladies and gentlemen, I'm down. We'd like to thank the tribunal for the clarity that they have brought to the proceedings this afternoon. I hope that if we're confronted with proceedings like this, we will know what to do and what we should not do. Thank you everyone for listening. Refreshments are served outside. Remember to put your name down so we can send you all the information from today. Thank you very much and have a good evening. CIArb 2018. For free rights to the Janada Center is being commissioned by the President of the Court of Appeal at 4 p.m. Mr. J.K. Gazama has invited us, so after the networking lunch, we can all go there. The address is J.K. Gazama Court, Damaturu Crescent, Abuja. Garki. Okay. The Honorable Israel Oluwanuga, the chairman of the Conference Planning Committee, will give out the gift of the Arbitral Tribunal. Yes, I'm sorry. If you wish.
I'd like to thank all the Mr. Arbitrators or the panel and all those who took part during this session. Thank you very much.